Sergeant Buchenek's testimony on cross-examination was the most devastating day of cross for the state. In my counting, he testified to at least 35 deviations from national evidence gathering standards. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. So in this video, I'm going to summarize the testimony of Sergeant Buchanek. I'm going to do that without reference to the videos, and I'm going to compile a chart as we go along of all of the miscues and mistakes, if indeed they were mistakes and not reflective of intentional conduct, that were made during the investigation and the collection of evidence. I'll put together a separate video with several of the more relevant clips that I believe are devastating to the state after I'm done with this video. The things I'm going to discuss in this video are 1. The investigative hierarchy and supervision issues, the initial scene processing, that's number 2, the evidence gathering and documentation, number 3, number 4 is witness interviews and statements, and then other specific evidence and observations. This summary is in no way encyclopedic or exhaustive. It's simply some of the main bullet points that I picked up on by listening to the testimony. Keep in mind that earlier today I did a video where I talked about the way it should be done. I'll try to link that up here. So let's get started. The investigative hierarchy and supervision. Bukhenik was Michael Proctor's supervisor and described the organizational structure as a paramilitary structure with the chain of command, which he stated was absolutely necessary for agency command and control. Yet, after describing it in this way, he demonstrated that he had absolutely no control over Proctor in the investigation and wasn't even read into many of the details. Bukhenik referred to Proctor's role as case officer or case manager, not lead investigator. He specifically did not refer to him as a lead investigator. He stated that a case officer's role was more significant than others, but not a major role, which he defined as 51% or more of the work, given the team size. This was an obvious attempt to minimize Proctor's role, given Proctor's clear bias. As a supervisor, Bukhenik was responsible for ensuring the investigation was adequately and properly investigated, including making sure subordinates gathered evidence appropriately and objectively, seeking out and ensuring no biases, and keeping tabs on those reporting to him, what they're doing, who they're interviewing, that sort of thing. He said proper supervision was a way to reduce the chances for mistakes and bias. Information was supposed to be shared so the whole team was aware. Proctor kept supervisors abreast of his work, including search warrants being written, evidence collected, and interviews conducted. Yet, in spite of him doing this, Bukhenik missed a lot of things that were done and had no answers for a lot of questions. So, despite these supervisory responsibilities, Bukhenik conceded that it's impossible to know everything somebody was doing. And I suppose that's true. That was highlighted when he couldn't authenticate unsigned search warrants presented to him, stating he didn't know what they were or who produced them. So you have unnamed individuals doing police work that you're supposed to be supervising, and yet you don't know who did it or why they did it or who signed off on the warrants and why they did it without your supervisory sign-off. That's pretty skeevy to me. Now let's look at the absolutely abysmal scene processing. And keep in mind that all the events that happened in this case occurred in the early morning hours of January 29th, 2022. If there was a crime, that's when it was committed. The crime was not strung out over a couple of days. The Massachusetts State Police took over the investigation from the Canton PD due to a perceived conflict of interest to alleviate any perception, not necessarily because one existed, according to Bukhenik. A strange explanation, giving the very clear conflict with Mr. Higgins and the Alberts and the McCabe's. As I discussed yesterday in the video where I talked about how crime scene processing is supposed to be done, the crime scene is the place where the events causing the harm could have occurred. It isn't just where you find the body. because sometimes people are shot inside of a building and they stumble outside and fall down dead. Here, the house at 34 Fairview was certainly part of the crime scene. It was a part of the crime scene on January 29th because it could not be ruled out as part of the crime scene. Therefore, in the exercise of well-informed discretion, the Massachusetts State Police should have secured the house, located all the witnesses who were in the house, and searched the house for evidence. They did not do any of these things. The sergeant testified on the morning of January 29th that he did not go into the house at 34 Fairview, did not secure the house or yard as a crime scene, did not conduct searches or take photographs inside, did not ask the crime scene services to process the house or yard. He did not set up a crime scene log. And keep in mind what he's saying here. No crime scene tape, no entry-exit log, no photographs of the evidence at the scene, no timeline as to when the evidence was discovered, or location information where it was discovered, all of which are gross deviations from national standards. Bukhenik contacted the medical examiner's office that morning and stated that O'Keefe was, quote, struck in the face with a cocktail glass, or at least appeared to be. This is a critical admission because it indicates that at least Bukhenik believed that he had been assaulted. If you get struck in the face with a cocktail glass, that is a lot different than being hit by a car. Bukhenik knew there had been a party at 34 Fairview, and that it was reasonable that if he was struck with a cocktail glass, that it might have happened in that place, 34 Fairview. But as I mentioned, he didn't do a search there. He also told the medical examiner that there was a possibility of a physical altercation. Again, that didn't have to have just occurred in the yard, and where there is a broken glass, it should be important to find all the pieces, not just some of them. If pieces are missing, the most likely place for them is inside. Bukhenik participated in subsequent searches at 34 Fairview and on February 3rd, 4th, and 10th. Now think about that. At least 4 days go by, and then on the 5th day, February 3rd, they go back to the crime scene and search for evidence. The crime scene was not preserved. There was no crime scene tape up. Anyone could have gone through that crime scene and dropped anything. Frankly, I'm surprised they didn't drop a typewritten confession from Karen Reed there in order to seal the deal. But at any rate, there's no way to know who walked through that crime scene. Well, there's no way to know now. The reason there's no way to know now is because the crime scene team, this crack group of investigators, didn't go look at the ring camera across the street, or if they did, they decided the information might make it more difficult to frame Karen Reed. So in either way, they violated procedures and they wound up spoliating evidence. On February 3rd, the first excavation with Trooper Proctor and Trooper Deco, items found included O'Keefe's hat, straw, and red clear plastic taillight pieces. Now again, 4 days have passed. On the 10th, so a week later, multiple pieces of red, black, and clear plastic and clear glass plastic fragments were recovered in the general vicinity, where the other items in Mr. O'Keefe were found. The defense pointed out that this general vicinity was a pretty broad area, 40 to 50 square feet. None of this evidence was photographed where it was. None of it was documented on a drawing. None of it was documented on a crime scene or satellite photo of the crime scene. In other words, there just was no documentation of where this stuff was found. Bukhenik interpreted the presence of taillight damage on the vehicle and the fragments found at the scene as evidence suggesting an impact. The defense suggested this involved assumptions and presumptions based on information provided or theories. Bukhenik stated they develop information, collect evidence, use it to suggest what happened, and that they use corroborating witness statements. In other words, they don't follow the evidence, they follow what these supposed witnesses told them and develop the evidence from there. In other words, you reach conclusions and then you work backwards to develop evidence to support those conclusions. As I mentioned, Bukhenik did not use cross coordinates or a forensic photographer to document the exact locations of these items, especially the items he found on February 10th. The report, number 83, only documents the items found and states they were in the same general vicinity. Again, that is absolutely terrible documentation. Evidence handling and documentation. That's the third topic. The gray sweatshirt and orange t-shirt were seized from Good Samaritan Hospital. Bukhenik and Proctor collected them there, finding them on the floor. They laid the clothing out to dry on butcher paper at the Canton office. Bukhenik left and did not bag the clothing. He doesn't know who bagged it. He acknowledged that for the 6 days the clothing was drying, anyone with access to the room could have handled it, including Michael Proctor. No log was created to document who handled the clothing during this drying period. Another gross deviation from national standards. Bukhenik collected the items found on February 10th. He stated he bagged these items himself, but he did not fill out the evidence envelope. He turned the bag items over to a member of the state police assigned at their office, relaying the necessary information, time, and location. He doesn't know who filled out the bag or whose handwriting it is, and cannot possibly identify which of the 4 potential team members he turned it over to. He refused to say it was Proctor, even though the jury likely saw the similarity in Proctor's writing and what was on the bag. The items collected on February 10th were not booked into evidence until March 14th, 2022, nearly 5 weeks later, and when they were, guess who booked them into evidence? That's right, Michael Proctor. Bukhenik could not point to any documentation showing the chain of custody for these items between February 10th and March 14th when the lab received them. He stated they were at the Norwalk DA's office before the lab. That is really hard to believe. It's really inappropriate. First, the DAs should have been alarmed at the lack of a chain of custody document. And second, the DA had no reason to inspect the evidence until it had been evaluated by the lab. Now, Michael Proctor submitted all the physical evidence booked at the crime scene at the crime lab on March 14, 2022. Evidence was also collected by Trooper Proctor on February 11th and February 18th, 2022, documenting items not observed by Bukhenik on the 10th. So it calls into question how thorough the search was on the 10th if you're still finding stuff on the 11th and 18th. Or it calls into question how those items would be found on the 11th and the 18th if there really was not some intent to sort of gild the lily here with additional findings, so to speak. Generally speaking, this is a heyday for the defense. They can tell the jury that these people are sloppy investigators and that none of their stuff should come in and none of their stuff should be considered by them. Regarding formal reports for the searches on February 3rd, 4th, and 10th, Bukhenik could not recall authoring them and agreed it was possible they were not written until November 4th, 2023, nearly 18 months after the searches. He acknowledged timely report writing is important, but sometimes is delayed in fast-moving investigations. Okay, I can get having it delayed a day or two, or maybe even a week, but he was unaware that the reports were delayed by more than 500 days. I'm sorry, you weren't out there busting your can for 499 days and then on the 500th day decided, oh gosh, maybe I should write these 18-month-old reports. On January 29th, Bukhenik interviewed 3 civilians, Jennifer McCabe, Matt McCabe, and Brian Albert, at a residence in Canton, not at 34 Fairview. These individuals were at that residence when the investigator arrived. The defense suggested they had a motive to lie if they were involved, which Bukhenik denied, saying that he took them just at their word. Now, generally speaking, if a police officer is interviewing a witness, somebody who was on the street and saw a shooting, for example, they don't just take them at their word. They background them. They look at them. They ask them questions. Why were you there? What happened? What caused you to observe this? That sort of thing. They don't just take them at their word. Could it be that there was some bias there because Matt McCabe is a police officer and Brian Albert is a police officer? I don't know, but Bukhenik found it absolutely not odd and totally normal to interview Jennifer McCabe at her home with Brian Albert, also present, describing them as cooperating witnesses. He later conceded that an investigator keeping an open mind might consider a cooperating witness could be a suspect who is lying. Gosh, you think? One of the things that Alan Jackson asked Bukhenik was, don't suspects lie all the time? And he said no, because that would mean that they were lying. Every single thing that they said would be a lie. And of course, he asked him if he didn't understand the colloquialism all the time, meaning it's simply hyperbole. And this guy just lied through his teeth and said, "No, I don't think that." That's the kind of testimony that really ticks off a jury because they know the guy isn't telling the truth, and I would bet you money that that officer or that sergeant has told people hundreds of times that people lie all the time, and now he's denying it in court. Unbelievable. Bukhenik got screen captures from Brian Higgins, which he understood to be communications between Higgins, O'Keefe, and Reed. This was not a forensic extraction performed by the state police. He just trusted Higgins, again, a cop, and verified the accuracy of the text using O'Keefe's and Reed's phones. After verifying he wasn't suspicious of Higgins' motives, the text messages read included exchanges between Higgins and Reed from January 13th to January 29th, culminating in Higgins texting Reed on the 29th at 11:32 a.m. that John died. Bukhenik was not aware during his investigation of a call between Brian Higgins and Brian Albert at approximately 2:22 a.m. He didn't seek to secure Brian Albert's phone, so how could he have been? Crucially, Bukhenik became aware of Ricky D'Antano and Heather Maxson as important eyewitnesses who were outside 34 Fairview in the early morning hours and in a position to see the SUV and its occupants. His report, based on Ricky D'Antano's interview, states the interview occurred on September 2nd, 2023, a year and a half after the event. Bukhenik conceded this would be considered untimely in an ideal scenario. D'Antano told him a dark-colored SUV was parked in front of the home facing Captain Street. There are numerous other observations. O'Keefe said he didn't see a contusion or a big egg on O'Keefe's right eye. He said there were some tiny, tiny lacerations on the right eyelid. So if that's the case, how could it look like somebody shoved a glass in his face? He couldn't speak to the broken bones or fractures other than the skull. Bukhenik was aware that no taillight material was found in the initial searches on January 29th, and none was found until after the SUV was in state police custody. Reviewing the waterfall video, Bukhenik identified Brian Albert and Brian Higgins facing each other, possibly squaring off or engaging in what could be described as wrestling or grappling. He saw O'Keefe elsewhere in the bar. Based on a zoomed perspective, he agreed Higgins might have been gesturing toward O'Keefe before leaving. In short, this was the most unprofessional crime scene investigation ever done. And it's not just me saying it. Two New York cops with a channel here and a YouTube channel from Las Vegas, two Las Vegas cops, said that it was unprofessional. The New York cops said they could never have gotten the DA in New York to take the case with his sloppy work. And the two Vegas cops are having so much fun with it that they're dropping cartoon call-outs over Bukhenik as he testifies. This is the extensive list of all of the miscues, mistakes, and malfeasance that I calculated out of the video that you just watched. It runs to 41 of them. One or two I could overlook, but 41 of these major errors, in my opinion, absolutely underscores how this is ripe with reasonable doubt. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.